ఒక నిమిషం ఆగండి. ఏం కదా అట్లనే వస్తుంది అది. Page wise mentions, page number 1, item numbers 6 to 16. Page number 2, item number 17 to 33.
27. Give the copies to the other side.
You're representing
Petitioner.
21. Okay.
File counter, my God.
Already, long time they have taken to file vakalat. I would next week.
They've taken long time for wakalat, so they need to submit also sometime.
Just now we received the papers, my lord. Just now.
Okay. 24.
Okay.
2 weeks is 24th. 24th November at request of council for respondent. 27 I think. 24.
Yes. Page number 3, item numbers 34 to 43. Page number 5, item numbers 44 to 48.
Item number 47. Petitioner counsel requested after 1 week matter already informed us as well.
Request 28 20 Monday.
Out of resolution.
Subject to the official intelligence method but criminal RC, wherein the father-in-law was roped in. Already 490 307 she has registered. Again she has registered the 307 method that is coming up for admission kind of used in spite of that notice.
307 against father-in-law.
Father-in-law and husband also, but the revision is only on behalf of the father-in-law. I don't use it.
Okay.
Yes. Take the
The matter is already compromised. Only for the compromise. Already matter was.
Okay. Have you filed all the required documents? What you will file? Unless you file, how can I list?
Compromise is already recorded in the general.
Hmm.
Copy. Both of them are already paid in the check.
Okay, file required documents. So let's fit on 30th November.
Announcement of maintenance in the last 2 to 6 of 2020. That's next year.
28th November.
Criminal RCs, my lord, petitioners are NDPS consumers. Because of state training against them, they cannot travel to abroad for higher. Can we have it every time next week?
Okay. 28th November.
Malaj criminal law 1353 Malaj earlier mentioned this matter on 6th Malaj interim orders are expiring Malaj. Not getting listed. I have even submitted a letter to the registry Malaj, but they're saying they're not able to find the file.
What to do with them? Not able to find the file means
It's like still Malaj, not getting listed on my location.
how can that be? File is listed. Okay, we'll list it on Tuesday.
Can I take it afternoon?
If the file is they are not able to trace out, can I list it today? Tuesday, find out whether file is traced out or you have ample time. At least. Today they can search. Because again, Tuesday is after 2-3 days holidays. Difficult.
CMA 2015 and 16 find hearing.
Inform the stand the insurance company or the owner of the vehicle will take it. When do you want? For final hearing.
Find hearing. Next week here.
Shall I list it on 20th or 17th? Give calculation, everything, all whatever is required.
Yes, I'm dead.
4 months.
4 matters. Okay, on 21st I'll take up. Give short synopsis. What ought to have been awarded, what is not awarded, whether it's a case of a death or whether it's a case of injuries or any disability, whatever it is, just to give synopsis. And the calculation also. What should be applied as a multiplier or whatever has to be allotted. And the income of the deceased. 21st.
Pronouncement of judgment, item number 1, D. Govardhanachari, GP for medical health.
Repetition is allowed, setting aside the impugned orders. The intervening period from the date of compulsory retirement to the date of reinstatement, that is from 12/6/2002 to 27/9/2006. 1,569 days shall be treated as on duty for all purposes. The respondents are further directed to extend all monetary benefits, including increments and revision of pay and pension, by treating the above period as duty, and pay arrears to the petitioner within a period of 4 months from the date of receipt of the copy of the source. Next.
Item number 2, Sri V. Rajeshwari, Sri M. V. Ramarao.
Writ petition is dismissed as devoid of merit.
Item numbers 3 and 4 are connected matters, not Sri Ramesh Chilla, Sri M. V. Ramarao.
Writ petitions are devoid of merits and accordingly dismissed.
Obliged. Copy by earliest minutes.
My copy is ready. I don't know when I read it.
Obliged.
This is final copy which will be uploaded today.
Obliged.
Item number 5, Sri C. Sai Reddy, GP for Services 1.
Writ petition is allowed, setting aside the impugned order of punishment dated 6/8/2020 and further order dated 15/12/2020, rejecting the appeal of the petitioner. Consequently, the respondents are directed to release the withheld increment of the petitioner with all consequential benefits within a period of 3 months from the date of receipt of this order.
For orders of court, item number 6, Sri Vidya Sagar A. Public Prosecutor. Orders of court. Numbering.
ఫస్ట్ కాపీ చదువుకుంటారండి ప్రొనౌన్స్మెంట్ ఆఫ్ జడ్జ్మెంట్ కాపీ చదువుకుంటారు పిటిషన్ రాలేదు
Complainant was filed.
నో రిప్రజెంటేషన్
He list it on 14th, 14th. No representation for petitioner. List on 14th. You want the copy, sir?
Just I want to look into it.
చదువుతారు ఫస్ట్
For admission, item number 7, Sri Katika Ravindra Reddy, Public Prosecutor.
It was on.
512 days delay.
So I'm sorry, this order passed by. Reports in the world. Not delay of 512 days.
Yes. Will issue notice to respondent.
Only 1 week time.
In 1 week you can serve notice. Take up on 22nd. Person notice is submitted, issue notice to respondent. Respond.
2 to 4.
2 to 4. 2 to 4.
2 to 4. Okay. Personal service also submitted through RPAD and filed the proof of the same. It's on now. 22nd notice. 22nd now.
Item number 8, Sri H. Sudhakar Rao, Public Prosecutor.
I please your lordship for the petition. Lordship, the instant criminal.
Dispensatory.
Finally, the order passed in the criminal appeal. Lordship, there is a delay of 336 days.
737
Lordship, it was mistakenly mentioned as 736 officer. The appeal order was passed in the month of September 9, 2022. After deducting the limitation days, it was 36 days, your lordship. It was mistakenly mentioned as a 737 days.
Okay. Challenging the revised order. We will allow this to dispense petition. Issue notice to respondent. Personal notice of the permitted will list it on the December 5th.
Yes, your lordship. Okay.
Item number 9, Sri S. Surendra Reddy, Public Prosecutor.
Reminding them of the district from yesterday. Saying this month, petitioner is not returned to this. And on 311 month, the chief examination of PWP was one of the recorded. Which is the first page. 18 minutes. Still, on 12/10/2023, the chief examination was recorded. And thereafter, month, but one more, I don't know. Then is 311. On 311, it's 18 months, the chief examination. Then after my filing charge sheet and my
Para 19.
Dispose about my sale with the meeting and then after registration of plan and filing charge.
Yes, in view of she expressing
There
the.
is no complaint. Even one of 13/10 returns. But there is no complaint at all. And straight away the language cannot even cause the order.
Remaining the petition document due to the state without even cancellation date, without even filing the application for cancellation. There are 23, not 23. But 20. Then for the regard for the accused also reported no instructions on the accused. There are the submissions. The witness is careful and based on justice, beyond the prayer of the prosecution and notice to be accused is reminded to do the justice. And doesn't if he intends to go for cancellation of the bail. There is no application or file as on the date. By recording this one, separate order is passed for which is a yes, sir. Entire chief examination shows not see the consenting party.
Yes, what is it?
Page 90 of the I told you,
Page?
page 90, there are 21 of the
Yes.
I did not inform that matter to my parents as they are with people. Petitions is cannot be received. All the family members are related to this. If the date of pregnancy are missing continuously threatening the cause, threatening the brothers and their consequences in case of the sentence. On the 31/10/2020 date of last pregnancy, their consequence and he is considered of the order number 13 of order. Very cancel in favor of the suicide threatening to the witness equal to the video recording of the response. Respect the future justice in the event of the aspects provided for the veterans respect of the video recording. The witness also produced one chain clause of the video and stated that is some add clause and the PW3, the medical record of file issued by the staff multi-specialty hospital. Page question for vocal and ultrasound scan report of diabetes, PW replacement, pregnancy, abortion, etc. Both these things, reports of private students. Go to sand is called ultra USB pen drive and market with the having of the site specified the certificate. Extract the contents by the prosecution and written service comes to the office. Retrieve the data text of the contents of complaint the section 65 of the certificate extra.
No, can such order be passed by the court below without the application made by the public prosecutor for cancellation of the bail? And see para 22. At this stage, in view of the life threat to the witness in the hands of the accused, learned public prosecutor prays the court to cancel the bail, detain the accused in judicial custody, render protection to the witness, PW3, and conclude the trial. At the most, they can provide escort the witness and leave her till she reaches her home. But how can they, without the application, detain the accused?
In fact, when the docket order, not that was not given. Page 7.
Yes, yes. Last para can be given. The grievance is with the first part, not with the second part, I think. Can suspend the order. What is your prayer? Suspend the order and
Allow the petition on bail. Because he is reminded to now in the
follow.
Yes.
But when the order itself is illegal, suspended, is it necessary for him to furnish sureties or he should be released? I think that would be sufficient. Why should he execute again sureties?
In fact, at the time of crime statement, aspect was very, very something.
Which court? Which court?
By the some court.
Okay. Yes, yes.
Crime state.
Anticipatory. And it was a conditional bail. I think.
Charge sheet for it was there.
Charge sheet is filed.
Right, it was not.
Trial is going on. Okay, okay. At the time of trial.
Yes.
This is only till the trial. Yes, yes. Maybe release it. Why should I say execute when order itself is illegal? Then it counts for the application. Forthwith. Release forthwith. Yes, yes, will get. All my copies will be uploaded. Immediately will be getting. I'm not recording much also. Just important one point. If not necessary, only I'm just small because you need to get copies if you keep on writing such a.
Item number 10, Sri Venkata Ramanaya K, Public Prosecutor.
Friday, kada? Holidays.
Juvenile Justice Board arrested the petitioner contents to 6
What
months.
is that? I could hear something juvenile justice.
No?
What is that? Juvenile justice. What you are saying?
The
Okay.
petitioner is the minor at the time of
How much is the sentence?
6 months. Page number 31. Accordingly, he is convicted of the same on the 625 charges and he is ordered to be sent to Chetan Hansal Boys Bandharamaram for a period of 6 months.
So what is the age of the boy?
Now he is the subject of
At the time
16.
16.
Target at 16 years, ma'am.
16 years, and what is the date of offense?
7/9/2017.
29/2000?
7/9/2017.
Okay. So before amendment. Otherwise 16 years also is a major. Yes, that will be done. Judgment dated 31/10/2022, single appeal number 1 of.
Item number 11, Sri Sheikh Ahmad Ali, public prosecutor.
May I please?
Yes.
The present criminal decision note is filed, appealed by the order of conviction passed by the appellate court.
What is the offense?
Offense under section 420, 268 and 120B.
How much is the sentence?
1 year for each offense.
Okay.
But my case before this honorable court is that,
This application is for accused number 5.
yes,
What is the allegation against?
but the allegation that has been leveled against them is that they have executed forged NOC of their sisters, and they have transferred the property sold the property to the de facto complainant. The FIR is lodged after a lapse of more than 3 years. Now my primary contention before
Is any criminal acts filed?
no,
Any of the accused in this case?
I'm not aware, my lord. I'm filing on behalf of 2 brothers. There are total 4 brothers.
No, you are filing on behalf of accused number
Accused
5. Whether any other accused has filed earlier?
As per my instructions, no, my lord, because it is my primary contention is that the first appellate court, without appreciating or reappreciating evidence, have clearly this cut copy paste order has been passed. Therefore, because they are directed to surrender on 15, so I'm seeking suspension of that sentence.
Okay, what do you say?
Basically, forgery case, Your Honor. So if something is paid, the lower court is sued at them. Petition is established on the beyond basis. They are field dealers, special courts.
The 2 of the major grounds that I have taken before this honorable court is that 1, there is no reappreciation or appreciation of evidence in the appeal. The appeal is an unreasoned order.
Now he is in jail.
No, my lord, they are directed to surrender before the court on 15th Tuesday.
Okay.
Now the other contention, my lord, basing upon an FSL report which was filed in a
Dismissing your appeal, they have directed to surrender.
yes, my lord, they have upheld the order of conviction passed by the first court. Yes.
And dismissed your.
And then, basing upon the FSL report which was filed in a civil proceeding, my lord, they have the learned appellate courts, both the lower courts, what they have done, basing upon that FSL report, they have directly attracted.
What is that FSL report regarding the handwriting? Regarding handwriting?
Yes, it is regarding handwriting in a subsequent in another civil proceeding. What has happened? There is a partition suit filed.
Okay, this FSL, the handwriting was, it was not sent in this particular case.
Yes, it was not in the particular in this case. So my ground is that in this criminal proceeding, no particular the evidence of the witness who gave the evidence in civil proceedings was not taken. No independent inquiry as per the Honorable Supreme Court guideline. No independent inquiry.
I just want to try to suspend it. By the Honorable Secretary District and Session. Notice to satisfaction of which group? Which group you have given for that? To surrender in 15 days?
For the trial court, that is judicial magistrate of first class at Zahirabad.
Judicial first class?
First class magistrate
Judicial first class.
at Zahirabad.
And what was the order for the appellate court? Surrender before.
It was upheld by the appellate court.
And what was the direction? To surrender before?
To surrender before the trial court. Kindly come to page number 22 for the last paragraph. Case number 1 and 2 are directed to surrender before the learned trial court on or before 15/11. And on such surrender, the learned trial court shall commit them to prison to serve the sentence of imprisonment imposed against them. The appellant accused number 1 and 2 fails to surrender or on before 15/11, the learned trial court shall secure their presence by issuing a non-bailable warrant and commit them to prison to serve the sentence.
Suspending so and so may be released also. May be released on punishing so and so. Security. 10,000. You know, I feel I think somewhere this accused number 4 I have dealt into. That's the reason I was asking you whether accused number 4 has filed. In case I'm accused number 4, which was I think similar matter, I don't know, 2 days back or something. No matter. Plus, Rangareddy. Think 4 kitchen to 10,000.
Question myself, the order of suspension is suspended. I mean, the order to commit themselves to prison of the appellate court is suspended. Why would a need to surety would arise? Why would a need to surrender or a question of bail would arise? If the order is suspended.
Order is suspended. Only sentence is suspended, not the execution. That is the reason you have to punish. It's pending criminal revision.
Yes.
Execution of the sentence is not suspended. Only the term sentence is suspended. Suspension of sentence, pending criminal revision. You need to punish surety. Otherwise, if you escape somewhere, who's going to get you? Without trial being appeal was dismissed.
Yes.
And you had a conviction order in the lower court.
Yes.
Then what to be done? That remains now.
Yes. Yes.
As on today, the order of the trial court remains.
Yes. It
So
has.
now you are convicted. You have to go to jail.
Yes. So we have.
So on surety, you are released. It's nothing but suspending. You are releasing. Like in a crime stage, you are given bail. This is after trial. So sentence is suspended, pending criminal revision. You are out. When the matter comes, subject to that, your in or out will be decided in the final. Who's your senior?
Number 12 is also.
Ask your senior about all this. What is bail? What is criminal? When it is sentence is suspended. So he's asking me all. He's having doubt.
CC today because Monday again is outside.
Okay. You can catch hold of one good criminal lawyer and you can have your doubts.
Being juniors and starting off with the practice, this is the first time I'm filing revision.
Without any senior?
Yes,
You are so confident and you're asking me only doubts.
That is why I tried to cleverly put a question to myself.
Cleverly.
But your lordship had caught me.
Lordship has?
Caught me
What caught me? You're testing me or you're learning?
I'm not testing.
Caught me means what? What did I catch you?
Since your lordship came to know that, I'm asking a question. I'm confused about something and I'm asking a question to the court.
I'm not only additional public prosecutor in High Court, I was in lower court also. So definitely I can give you, but we can't waste time and give you a lecture. Others will feel we are giving some debates here instead of giving orders. Okay. Anyway, you are new to the profession. Good luck, but you should always have doubts, but take from your seniors. Judge should get assistance from the advocates, not giving lectures.
Yes.
Item number 12, Sri Sheikh Ahmad Ali, Public Prosecutor.
Jail superintendent. No, but the order is suspended by, court order is suspended, they should know. Directly to the jail. So,
Unless that is my direction, special direction is there, then they are
so I should give it to the superintendent jail. No, because I have given it suspending, I have directed to the court below to forthwith release. So you should take a release order from the court. You should take a release order from the lower court in view of this. Why immediately you can take, you can download the copy and you can file the, let them know. What kind of order is called?
Direction given to court below.
To the court only. No other, it is to the court only. To the court. Principal district and session judge. It is to the court. If you want immediately, we can take a download copy. You can make an application in the court below. This order is suspended to release so and so. Then you have, you know the procedure in lower court. You need to take a release order, go to the jail, and within below before 5 o'clock. Direction court only, because this is not something you are being released on. If you are convicted, you are in jail on medical ground or something. We give it to the jailer for a short period. Personal bond.
So that again, when the court may, while passing with the order, the court may direct mass punishment.
Okay. As revision is being pending.
Please go on pending there. Please pending there.
Then I should say 10,000 to surety. Release the petitioner / accused. Punishing of 10,000 to surety. Okay. So the court immediately. Not your matter, his matter 10,000. Yours also 10,000 accused. Okay, next.
Even 12 also.
Oh, yes, sir. Item 9.
Item number 12 is the same antagarana.
12 is of the same.
12 is same, but accused number 1 has filed. Yes, brother, accused number 5 has filed item number 11. Similar.
Okay. Well, practice number A1. Okay. Petitioner / A1. And first one is A5.
A5.
Petitioner / A5.
Item
10,000 to surety.
Yes.
Item number 13, Sri K. Kiran Kumar.
Hey, please, my lord. Lord, this contempt petition is coming for the first time, my lord. Notice may be ordered, my lord.
Contempt. 30.
Okay, notice to respondent 192.
4 weeks, my lord.
December 5th, 4 weeks.
Much obliged.
December 11th.
Much obliged.
Item number 14, Sri Srinivas Rao Madi Raju.
No representation. You're the
Contempt.
notice to respondent to 1 to 3. List on 11th. December.
Item number 15, Sri M. Ram Gopal Rao.
No representation, Your Petition. Fixed on 21st November.
Item number 16, Sri A. Narasimha Rao, Sri Kiran Kumar, Sri Kiran Palakut.
Respondent also is seeking time for counter.
In this matter, revision was filed 2 weeks ago. Revision is filed against a dismissal of application filed in order 7 rule A and D.
Order 7.
Rule A and D. Suit is not maintainable on the ground of suit for
CRP.
The plaint is based on this. Suit is posted to 16 for further evidence for Washington County. Limited schedule and legislative as one for your locking disposal reasons. Gratitude is used this thing. So that is work preventives of purchase property from Lamna and dependents of purchase and wife of Lamna. This is 2.3 acres for the survey number.
Petitioners purchase from whom?
Petitioners purchase from wife of Lamna.
Wife of Ramna.
And respondents purchase from the Lamna.
Husband and wife.
There is vast extent in the survey number. And petitioners filed caveats and served caveats on the respondents. They filed a suit. Entire trade developments on the basis of the title of the suit. So they filed only suit for simple invention. That a suit for simple invention is not maintainable when the cloud is classed as title.
Yes, unless title is.
On that basis, we filed application. The learned judge, instead of going into the, I will frame the question, instead of going into the maintainability of suit on the basis of non-seeking of declaration, went on the limitation plea. Limited. Yeah, I'm not a limitation, I'm not a cause of action. So I'm only on beyond that. Once plain developments clearly show that the basic title, the disputing my title, when the dispute of title is there.
Okay, only simplicity injunction they sought without seeking a title. Okay, according to it's not maintainable.
I'm only getting limitation of the written by the controversy.
Yes, meanwhile, state.
State lordship, senior will argue something, but kindly short.
Yes, yes, meanwhile. IA 1 of 2020. We also sufficient address this court is inclined to stay all further proceedings in OS number 1 of 2020.
Page number 2, item number 17, 340.
Only till 24th.
I'm ready.
340 Gari Sridhar Reddy.
May I please? Since CRP is filed, may not be by the order of the Immediately, may not the petitioner before by lots filed a suit for injunction. Nigeria under order 39, 192, filed a retrospective application 573 of 2017. Seeking not to interfere. Petitioner scheduled land during the pendency of the suit, not to disturb my lord the flow of the water and damage the pipeline, my lord, which is leading to by trees. Right, in fact, my lord,
Okay, what is the reason given by the court below for dismissing the application?
Page 7, my lord. Page 8 is the order.
Page 8.
9, my lord, the contents and lordship's page 10. Considered, my lord, the issues framed by the Abdul Bakr. If one can read that, man.
Which point?
As paragraph number 12.
Yes.
As can be seen from the rival contention, even after acquisition of the schedule provided by our two and for the purpose of letting for reservoir in the year 2005, still they are in the position of the acquirer of the land, which authorities will to take compensation for the standing to their increase. The petition schedule property is situated in survey number so and so an extent of 25 acres has been acquired as and half award dated 2007, number dated 28/3/2008. That's fact is not disputed by both the parties. Therefore, the criteria was based with the auto and applicant, but either the appellant or the respondent made. The learned transport went on the basis of the feelings of the parties and came to a conclusion that respondent made has made out a prima facie case and balance of evidence in such united intention against the appellant. The order and decree dated 9/3/2018 is not based on any document with regard to the question except on mere pleading. It is a fundamental basic principle of the civil and that the pleading session will be proved by the documents of the arrest. Now the parties have filed any documents showing their position over the question scheduled for party, even after acquisition made by the author and artist in the year 2005 and after passing the award in the year 2007. In a case like this, one has to prove the prima facie case balance of convenience and able to law damage so as to seek intelligence of the document by granting teacher. The relevant by granting the injunction as observed at para number 7 of the observed on 23 calendar. On provisioning the elements of the petitioner and the count of R1. The land is survey number 38 and 40 of Utipura village of the Mandal was submerged under the Litapa reservoir and government acquired those land properties. The award 196 of 2007, 28 and the compensation also paid to the concerned parties. However, the petitioner and R1 came forward by claiming the respective grading trees, stating that for trees no compensation was paid by the government. If such is the fact, without hearing R2 and R3 sides, the absolute right over the standing fruit bearing trees cannot be decided. However, the petitioner and R1 insisted to dispose of this petition. The allegation of the petition is that R1 is obstructing the flow of the water in scheduled line of the standing fruit bearing trees. In that connection, the R1 is directed to not to obstruct the flowing of water to the trees for the petitioner and further directed not to damage the pipes so if the water supplies the fruit bearing trees. Similarly, applicant also did not file any act of document evidence position of the scheduled line. In fact, after acquisition, the title and position paid to the government also and RP. In a suit for injunction, the primary question to be considered related to possession. Though the question of the title also may fall into is written. A person in possession, though without title, can interfere from another who has no better title than him and get injunction. Thus, the observation is made by the transport while granting injunction is without any base and basing upon the assumption and presumption and cause an order of injunction, which is totally illegal, arbitrary, and not according to the law. The same cannot be allowed to stand. Thus, the respondent has failed to make out any prima facie balance of convenience and therefore not entitled for any leave, much less so and so. But this is the point. So, it says that, my lord, admittedly, the award has been passed. By a repetition. My lord says, under 24(2) of the Act, my lord, when they have not paid the entire compensation and position of the property, they are entitled to redemption. I have filed a repetition that is pending for adjudication. Now, my humble submission is that, my lord, I am not seeking anything, my lord, injunction not to enjoy about the land, flow of the water and damage of the pipeline, except that I do not have any grievance. And I have also filed a representation, my lord, to pay the compensation for the trees also entitled as my lord knows. My repetition is pending for adjudication, my lord. I filed a copy of the same, my lord, page 81, my lord. Mentioned about all the representations and my prayer, lordship may look at this prayer, my lord. My lordship will get it in page 87.
Yes.
This award the issue and appropriate for our consideration of the respect to land building and award so and deemed to have been lapsed consequently directed as far as to doing notify the land acquisition. It is to be a motion. This issue is pending. My limited grievance is that, my lord, let them not disturb the people during the pendency of the, my lord, CMA, my lord, they do not have any orders. But my lord, IA have an order and also full aid is also granted by this normal time. Page 27, my lord, full usage. Page 27, my lord. IA number 288 up to 2018.
Reviewed by the CMA is filed by them.
I mean, the CMA. In CMA, my lord, there was no interest suspicion for that. This is the final order. I take out notices, my lord, let them protect my interest in that. Two trees are there, my lord. My main idea is also for that only. They do not disturb free flow of water and damage the pipeline.
Where is this order dated 9/3/2018?
9/3, my lords, page 49. peaceful. Cooperative question, page 54, bottom two lines, my lord. Link page 54, bottom two lines, my lord. Continuation 51. The connection the responding one is directed not to obstruct flowing of the water to the trees or the pitcher and directed not to direct them. Two trees, my lord, there.
So against this order, CMA was filed.
Yes,
And it was allowed. And against that, agreed by that, you have filed it.
exactly.
Here IA1 and IA.
But IA 573 of 93.
No, no, here.
That I think.
In the CRP.
Yes.
What is this IA? IA1 of 2023? To grant add into
In,
how can I?
restricting obstructing the flow of water. What's in the third lane I mentioned that restraining respondent obstructing flow of water to the trees covered under the sewage property. And the latter the picture not to damage pipes through which water is supplied to the
Instead of seeking to grant ad interim injunction, you should have sought for suspension of that order. Restraint.
Well, that we are lost, modify that order in that order. Meanwhile, I take steps for. I'll file another.
Without hearing them, your
In fact, during the pregnancy of the IA, my lord, you know that IA was allowed in favor of me. I was in interim order. And in CMA, my interim order was not suspended, my lord. After passing the final order, I agreed by that I gave it for this man.
IA1 of 2023 is notice also permitted. File the proof of this.
Item number 18, Sri K. Hanmandulu, Sri S.R. Sanjeev Kumar, Public Prosecutor.
Hearing for the response number 2. Last date, I made a representation that the previous criminal RC 2169 of 2018 was disposed of by lodging the restaurant. The same proceedings and the same date, only the check was different.
Where is the petitioner counsel? You are for the respondent.
For the response. So the concurrent finding given by the trial court and the appellate court regard to the case. Agreed by the same, the revision was filed. There are two criminal RCs being 2168, 2169.
It's connected with this matter.
It was connected to this. A common judgment was pronounced in both the cases.
In this matter also.
Judgment of the trial court was on the same date. There are two check bounce cases filed by the complainant. Against the
This
same,
revision is filed against which order?
against CC.
Okay, let the petitioner counsel come. Let him come.
It is not appearing well. That's
for the reason I made a submission that on the same footings, this criminal RC can be disposed of.
But it's filed by the petitioner.
Yeah, that's what he's not making a representation. I am making a representation on behalf of respondent to see that the case can be disposed of.
Please let them come. No
Your
representation.
lordship can have this order copy in the
Yes.
file so that it can be produced by this court even on the other day.
No representation for the petitioner. List on December 15th.
It's too long.
Too long, but I don't.
Item number 19, Sri Prabhakar Chikudu.
28th November in written. If he comes, we'll see. When he's not bothered, what to be done.
Item number 19, Sri Prabhakar Chikudu, Public Prosecutor, Sri C. Haripreet.
Short password.
Just like kindly, what for the remarks and
Protest petition.
expedition.
Protest petition. What records will be there?
Already so many statements and we got.
We have filed.
Yeah. Protest petition. What record? Will be? If you're not ready, I'll give time. Protest petition.
Tuesday.
14. Come next Tuesday. It's coming Tuesday. With request of counsel for respondent. 14.
Item number 20, Sri V. Durga Nageshwar Rao, Sri Palle Sri Harinath, Public Prosecutor.
So in this matter, the DVC matter, in this matter, the petitioner is the wife, the first respondent is husband Miller. She filed as a DVC Miller in first additional judges certified Miller. At the time of Miller, the compensation was 10 lakh rupees was award Miller. Then after Miller, the husband has preferred and appeal Miller in 26 of 2020 Miller. The compensation reduced to 4 lakhs Miller. Then after
10 lakhs to 4 lakhs.
4 lakhs, yes.
Agreed by that, you have filed this review.
Then they filed a revision petition. The matter is coming for hearing. At the time, this non-muscle Miller given direction. Only the appeal judgment is filed Miller, but DVC order is not yet filed Miller. This court has Miller specific direction to file a DVC order along with depositions.
Have you filed now?
Just 1 week, 10 days time Miller, I have received copy. 10 days time Miller, I filed it. 28th, 29th, I filed.
Okay. I'll list it on December 5th. We can hear it finally. The request of counsel for petitioner for filing material in DVC list on 5th December.
Item number 21, Sri P. Ramasharana Sharma, Public Prosecutor, Sri N. V. Ananta Krishna.
I am for the respondent Millets. I am for the respondent Millets.
Yes, both of you are online.
Yes, Millet.
Yes, make it submit.
Lakshmi, kindly have it next week, Millet. I will appear physical, Millet. Some inconvenience, there's some noise is going on here, Millet. And actually, this is Millet 22.
Submission Millets. My friend has obtained stay on a condition of payment of 30% of deposit amount. Proof of deposit is not filed till today.
Millet, I'll file it. Next Tuesday, Millet.
Deposited the amount?
Millet, I have no instructions, Millet. I'll take it. Kindly have time, Tuesday itself, Millet. I'll give this up.
And without having knowledge of depositing, you were giving.
Only Tuesday, Millet. Next working day. Next working day itself, Millet, I'll submit.
Okay.
If it is not deposited, it will be Millet.
Not deposited.
Cannot be Millets because the time limit is fixed. It has to be done immediately. And
Yes,
this is of 2022. We are in 2023 fag end.
Yes, sir. If it is not deposited, it will be considered Millet. I'm not saying that. But I'm not seeking any relaxation.
Okay, take instructions and file it.
Very well.
We list it on 22nd November.
Very well, Millet.
Obliged.
Item number 22, Sri Ajay Kumar Madisetti, Public Prosecutor, Sri Bankat Lal Mandhan.
No representation on either side. List on 21st.
Item number 23, Sri C. Hanumantarao, Public Prosecutor, Sri Pratyusha Bopala.
Representing for the respondent.
Actually, before the trial court, before the appellate court, trial court's execution of trial court sentence was suspended on the condition that the appellant should deposit 20% of the check amount. But that was not deposited. In spite of it, the appeal was disposed, confirming the trial court judgment.
Now he's in jail?
No, he is not in jail.
Yeah.
He
It
never
is suspended
appeared.
here.
Yes, he never appeared before the appellate.
No, it is suspended before this court.
It is again suspended before this court without insisting on any deposit. Having obtained that, they don't come before the court for disposal of the appeal.
Should have insisted for deposit of 20% of the check. How much is the check
I
amount?
was not under notice when that was given. 8 crores to 60 lakhs would be. But so much of amount is enjoyed by them. Repayment is a pain, but
Yes, at admission stage, I think it was suspended without any condition.
comes to repayment, lot of pain and suffering will come, but that 88. The case rests solely on 2 documents to show the liability, which are accepted by the accused himself. These checks are given along with a covering letter accepting the liability. It's an open and shut case, but
Yes, very fine. But without any condition, it was suspended. Surrender and Now what to be done?
I like to post it to final hearing with the condition that if they don't appear on the next date of hearing, the appeal will go on for final hearing with the speaker. Treated as well.
It's coming first time before me. I will give an opportunity.
Having obtained this order by suppressing the fact that they did not deposit 20%. And having obtained this order.
No, before me also it came before the other bench, but it's coming before me first time. I'll give an opportunity. We'll see next time.
Specific date.
Which date shall I give?
Any legal date for me.
The 28th or December 5th? Which? 20. No representation for the petitioner. Counsel for respondent present. List on 28th November.
Item number 24.
Language and surrender, I will claim 2 matters. Two matters. Is suspended. Like suspended and they pay the reason. Directed to surrender before the trial court and gone. Before so and so court and later and actually a court and before the trial court and gone to surrender from is ordered to be in right on. So which issue is the license satisfaction? Okay. Interlogic application. Break to outline classification. That is the grounds of next.
Item number 24, CP Rana Kamalasan, Public Prosecutor, Sri SB Mohammed Ibrahim.
Made to your lordship. I have filed an application to receive the additional document and there was a delay. Put this.
Delay.
Okay, who's the you're presenting the
Defect of complaint.
Additional document of delay in representation.
what do you say regarding the delay?
Okay, the only delay in regard to the representation of the IA which was filed and I already filed the copies.
Okay, resubmitting. Resubmitting.
IA document says.
To receive additional documents.
Yes, ma'am.
In view of the reason. Yes, got it. That's right for it. Have you given the copies?
Earlier at the time of pendency.
Deny.
Every time finance wants copies, I have no objection, I can serve number of
Okay,
copies. But here is the case.
Okay, so copies will hear next.
You see, the matters of urgency, so interim civil granted in case, the Lord is well aware.
This is discharge petition.
Yes, my lord, there is a case and counter case there, my lord. The law is always there that both should be tried together, but here is the case. It's a unique case where the police in collusion. In fact, this matter was.
On what ground you have filed this discharge petition?
Discharge application is, my lord, it is a case and counter case, and in the additional documents I have filed, the case which I have filed, that went in quash. That quash, their case is quashed, and I am now in the docks. Wherein I have gone to the police station at 10 AM, but they made me detain the police station till 12:10 PM. They have registered their case after receiving of my complaint and given crime number first to them at 21 and 22. It's a case and counter case. So the
Your crime number is?
My crime number is 22. Their crime number is 21. But in fact, I have
What is the time of incident?
Time of incident is 10 AM. I have gone to the police station before 12 only. They have come to the police station when they inform about the case registered. They came there and detained me till the other side wants to come. So there they say that both the complaints are received at 12. I am a physical challenged person. I was before them, and the case which is registered only on the technical aspect that the permission is not taken. They have taken the benefit of it. Initially, the FIR registered against both the parties for the same sections. The document gives us
incident is the same.
Same incident.
Same incident and you
I have gone to the Supreme Court. This party, the first line of their complaint clearly reveals about the civil suit pending. When the civil suit is pending, their suit is pending because they are not the winners. The matter is between this land is of protected tenancy land. So the landlord in collusion with these persons, though they are my relatives, they are not the beneficiaries of the land. So they have started the litigation in collusion with the landlord in the year 2005. There is no.
So your IA 1 of 23 is allowed or pending? IA 1. I think it's pending. Your IA 1 of 23.
Before this court, yes. So I request some short release. So can we finally dispose of?
Yes, wrongly?
Oppose.
Why?
Oppose his contention.
Do you deny there was a case and counter case?
Yes, my lord, that is there. That case was quashed by the Honorable Court.
What was quashed? Crime number 21?
Yes.
What about crime number 20?
Crime number 21.
I understood what he said. Crime number 21 is they went first, but your crime is registered first. Crime number 20. What about crime number 20?
I agree with that, my lord. They tried to tell me actually we have filed a petition to change the section to add this.
What ground it was quashed? What ground?
That technical ground.
What is the technical ground?
Technical ground, without obtaining permission from the magistrate, he has made out the case. That's what I think so.
What is that offense? Why?
24, 5 or 6. That I have filed in additional material papers.
Without taking the permission of?
For investigation for non-cognizable offences.
Okay, it's non-cognizable.
It is registered against both the
Both
parties.
the crimes are not cognizable.
Yes, sir.
Both the crimes are non-cognizable.
No, both all same, but though they have registered 324 on my complaint, but they have, while the filing charge sheet, they have made only 323. So only even the public prosecutor, Mr. Sudarshan, has strongly opposed, basing on the judgment, but however, the lordships came to the observation that it is just to be quashed only on the technical aspect.
Whether in your case cognizable or non-cognizable offences.
My case is charge sheeted. They have made me as 324 in present case. But based on my
In your
complaint,
case, 324 is there.
324.
So 324 is cognizable offence.
6 and other sections are the charge sheet.
In your case, 323.
Yes, though FIR was registered against 324, but in the charge sheet they only they have added as 323, and basing on their simple benefit, they have gotten the order of quash.
What is the doctor's evidence?
Doctor's evidence, both the cases simple in nature, simple in nature. That I find the medical certificate.
Both the cases.
Simple.
What is the weapon used at the time of incident?
Weapon used, they have simple slapping. They say
in both the cases.
Yes, ma'am. But in the cases, I have said sticks and other things. That objects, material objects, what they have deposited, I have to take the copies also. But
your complaint is regarding sticks also.
I am physically challenged.
What is their complaint? With what they have slapped or?
That complaint. The FIR, page 15. Received a complaint from Narmada, so and so. Along with them, went to Shivalayam, to Bajirath Buddha, Golubhis, to Chinnabavi lands. Third of mention, reading at 10:30. On Vasu, who obstructed them and asked them why they were passing through China, abusing Indian language, such and such, and trying to beat with crowbar. But no crowbar received. They gave the complaint with crowbar. Complaint party stated that Vasu, so and so have repelled the complaint and son near to the ref. While the quarrel was happening, the complaint husband and daughter interfered and tried to rescue them, but all the accused persons should have the previous judges regarding the civil suit OS 1863 of 2005. So since 2005, the litigation is there. If I had more grudges, I would have every day, because they are residing near opposite to my house only. There was no necessity for me to take this.
Have you filed your complaint also?
My complaint has been filed. Page 48. Page 48 is crime 22. This should be 21, but they have received admit 21, and this is 22, where I am the husband of these petitioners, lost the complaint. Wherein the Narmada is A6, and the page 52. May I read, Bharat? Page 52.
Yes, to me.
Brief facts are there. On 13 February, received a complaint from Vasudev, son of so and so, occupation residence so and so, in which stated that on 13 February at about 10 hours. My complaint, as per this, is at 10, but their complaint says that at 10:30. I have attacked them at 10:30. When my complaint is at 10, A. Bhimraj was already involved in crime number 12 of 2018 under section 431 IPC, entered into land illegally. That is one of the accused in my complaint. Illegally with A. Narasimha and picturing his land and started scolding with bad words and saying so and so. Along with his father, Babesha, Usha Gaud, daughter of Babesha, A. Narmada, wife of Babesha, they are all attacked on me with the dangerous weapons, knives, sticks, stones, and tried to kill, used by which he and his brother Chandrasekhar received blood injuries, and seeing the injuries, his family members, so and so persons, while tried to stopping them, and again started abusing his vertical. So these sections they have registered as 324, 504, 506, 447, and read with 149 of the APC. And page 53, they made me to wait at the police station. Page 54, they have received it on 13 February at 12:10. As per the content, above case registered in 324, 504, 506, 447, read with 149 has been registered towards the investigation. But their FIR only is with regard to the
go through the witnesses, LW's deposition.
The FIR, the sections.
Before them, eyewitnesses, 3 eyewitnesses are there.
Their sections are 324, 504, 506 in the FIR, read with 149, and while laying the charge sheet, they have made it as 323.
Whereas in that case, the LWs are the accused here. 3 accused are the LWs in our case.
I have filed the charge sheet also, page 61.
So page 14 is FIR against you.
Yes, ma'am. Yes.
Where they mentioned date as time as 12 o'clock.
Yes, ma'am.
And 21 FIR has been given.
Yes, yes.
And on page 47 is 12 o'clock, 10 minutes.
Yes.
22. This is your complaint.
Yes, they made me to detain, and in the meanwhile they have informed them. But whereas my complaint says sticks, stones, and other objects used in them, 149 is there, and the charge sheet, your lordship may kindly see when such is the gravity of the offence. In the charge sheet, your lordship may kindly moment last page 62. Keeping the same dispute is a charge sheet filed against them. Disputes in the A1 to A4 as mentioned above picked up for with the complaint scolded them and abused and threatened with direct consequence on 13 February morning around 10 hours in Golur limits. Thus, the acts of the A1 to A4 constitute Article 323, 504 and 506, Reg 34 of the Indian Penal Code. There is no explanation with regard to how 324 was made to 323 and why they have negated 149. And so on and so forth. The title declaration is still pending and all of them are claiming to be the owners of the property. That itself constitutes this dispute purely is of civilian nature. So only to see that I surrender them for some compromise, these types of litigation is going on. But whereas my complaint, the FIR completely reveals the son of the respondent number 2 is already involved in crime number so and so, crime number 12 that I have brought to your lordship's notice. Page 52, Miller.
This that has happened on this
I hear you. Let him complete.
Page 52. That the A. Bhimaraj Road is already involved in crime poll of 2018 under section 435 APC entered into land illegally with A. Narasimha Road. So I went to the Supreme Court. I am in the possession. I am cultivating the lands. This respondent number 2 has no business to come into my land. They come into my land, create troubles, trespass into my lands. Being a physically challenged person, they harass me. In fact, my lord, I have also reserved my right because your lordship is well aware. A physically challenged person, if is attacked with the other IPC sections and the other special provisions of law are there to attract. So they have completely suppressed and they remanded me. Fortunately, I went there and got the rescue, but they have falsely stated that 41 is complaint to me.
Okay, that's what.
This thing has happened on Shivaratri day. Shivaratri, that is Jagarana in Tarvata Shivaratri. On that day, the mother and son.
How does it mix whether it is on Shivaratri day or some other day?
There is not. The temple is other side, village boundaries. From the land itself only they have to pass to the temple. When they are going from the temple from the court, this person has the Vasu, Mr. Vasu, why you are coming into my land? He attacked there. From there he attacked, and when the mother and son came to the village, before the houses, these accused, his brother, his wife, his son, all of them attacked and fought, beaten them. All the village, before all the village people, the remand report and the eyewitnesses also clearly saying that there is a offence committed by them. Having committed by this, they went to the PS and sat over there. Further, Milord, they are having full influence people. They are the only people. He is ex-sarpanch of the village. They managed the police and got registered this case. In the other cases also, Milord, in each and everything they are going on. They tried to murder them actually. Two people have been in the civil case. 2 people has, after giving evidence of PW evidence, not given evidence, only after filing evidence of it, they have been died in suspicious circumstances. Now, after I came, it is the suit is for legal aidship. It is coming from 2005 until now. Now evidence is regarding.
I think one of the properties is issueless.
That is that 1 minute. 1 minute. That is also, that land is Yanam land. No ORC has been granted. As on today, that land is government land. A clear order, the RDO is there. Nobody shall involve, nobody shall interfere in the land. There is a order. Then when the ORC is pending, when the LR petition is pending, till the LR petition is disposed of, who are the LRs of the deceased
Then how are you claiming your right?
I am the legal heir of the legal heir of the deceased tenant, protected tenant.
Deceased.
Ramalingam.
Plus, my lord, my grandfather also one of the tenants. My grandmother also having 16.5 acres. She is also in as on the date of vesting. We are taking so many steps are there since 2005. He is prolonging the matter. He has filed in a half a dozen CRPs before this honorable court and kept pending that.
All CRPs are.
Whatever, all CRPs dismissed. And now he has filed, having filed before this honorable court, he has filed a transfer petition before the district court. Yesterday it was there. We waited up to 5 o'clock. He didn't appear. He promised to come by 4 o'clock. He didn't come. This case is exclusively characterized. Actually, 307 would have been attracted.
Such petition was dismissed.
Whatever it may be, we have taken steps for that. He has pressurized and managed with PP and also the police, and there are going on tensions over there. Actually, we are the two are the brother and sister of the advocates. They are not in a position to move freely. Whenever they attack, more in number, more in influence, and having money people. Those are the father died. Both advocates are children unmarried. He's recently married that lady, that girl. That girl before marriage, they tried to kill her in the witnesses says, and they are seeking this. He has filed class petition. It is pending. It is not coming. He is not taking steps to coming on record. Accused 1, 2, 3 have been already committed, and 3, 4, 5 disaccused. These people are the persons who have tackled and tried to manage, tried to kill the complainant in this LW2. The witnesses say what I am saying. I am not saying on my own. The remand report and the LW's eyewitnesses, your lordship may go through it, and having gone through it, the lower court correctly rejected their petition. They won't deserve for any relief. Your lordship's discussion, I want.
My lord, I am going to file the petition what they have filed. If it is a government land, my land friend have no say in OIC. They say they are taking different stances. It's a particular land. The Supreme Court order is in my favor. The Supreme Court is an order in my favor. I will file the document and helps you. Because he is not a party to the Supreme Court. He is colluded with the Patadar.
My brother-in-law, he is the assessor. Whatever it may be, Lord. Those situations, these facts are no way concerned with this case. This is a case where they try to do away with the complainant and his family members, whose house is opposite to the house of the accused. Before the house and the house itself, all these things have happened. From the land to house, they have been brought them beating these people, mother and son. And there, when the daughter and father tried to solve the problem, they attacked them and they tried to kill that daughter, who is taking up and looking after the case, being an advocate. Son and daughter, Usharani and Bhimraj Gowda, advocates.
Sure.
She has been beaten up like anything. 2 times she thrown away by plucking her hair. Immediately they went to the MLC. During this period, they have manipulated everything and managed with the police and got a handwritten complaint. In hurry and worry. The complaint also filed by them. Police also fully managed by them. Actually, they are not cooperating with me. The Bhavesha with the Tatta Swami, he was recently died. Recently died.
Natural, it's a natural death.
Even natural death.
You have got options, whatever
There
offenses
is
have been taken.
a doubt. ప్రాణాలు చేతులు పట్టుకొని తిరుగుతున్నారు వాళ్ళు. వీళ్ళకి ఎంత తెలుసు
పోలీస్ ప్రొటెక్షన్ తీసుకోండి, సివిల్
పోలీసు వాళ్ళు
ప్రొటెక్షన్ తీసుకోండి. మా వాళ్ళు ఎందుకుంటారు
వాళ్ళు
వాళ్ళు
అడ్వైజ్ చేస్తున్నారు, ఎందుకు వదిలేసేయండి వాళ్ళ గురికి ఎందుకు పోతారని చెప్పి పోలీసు వాళ్ళే గైడ్ చేస్తున్నారు. పిల్లలు ఉన్నారు, వాళ్ళ కోసం పోతే మీ జీవితాలు నాశనం అయిపోతాయి. Reality, what I am saying. Also by practical things. జ్ఞానం ల్యాండ్ అయ్యాను టుడే. దానికోసం ముందు పెట్టిన ముందు పడుతున్నాను.
No, this was quashed, but did the police file any application?
Yes, filed application, they have what they will steps take, we don't know, let them take whatever.
Okay, under 155.
Yes, they have filed, I think so, they have given notice to me.
Your Lordship, whether case and counter case, how has to be dealt with. Your Lordship, can you peruse the Supreme Court order, Miller? They are not.
No, however,
Facts are most important.
Supreme Court order.
See, LW is similar, they in the case, LW, all the LWs are the accused in this case. The persons who have.
what did they say about the case?
Because Supreme Court judgment was decided in 2001, since 76, that I will place all the materials if some date is posted without a replacement. What Melanford says with regard to the 307, the case was registered in the year 21. After 3 years, they are, what is the protest they have made? They know the charge sheet. They themselves say that they are the advocates and they are risk to their life. They can take the appropriate steps. I am not residing in the village except Vasudev Gaud. Nobody is residing in the village. Then where is the question of apprehending or risk to their lives? They are all making stories. Once they say it's a government land, it is covered by the government land. This is the order of the Supreme Court. Because the landlord lost the battle in the Supreme Court, they have created this parallel litigation in the year 2005. They were well expected or forecast that they are not going to win the case. If they are legal here, would not protect succession of protection was granted in the year 74.
You filed the case, why are you prolonging that since 2005? By taking the adjournments to prolong the issue. The LR patient case is 18 years, sir.
The degree copy,
18 years.
the degree copy shows the names of the family members.
Yes, Yadagiri is the brother of the Babesha, sir.
It's not trial court or now you are conducting any trial here. You need to make submissions, I need to come to submission. Being serious, I'm just waiting, watching your amendment, that's all. Which paragraph?
The last statement. The schedule 2, that is the equitable order for remaining, which were died as the last 3 pages. That's the amended possibility and it is a decree document of student. The Ishwaraya died by nurse, Anusuyama, wife of Ishwaraya, Dayanand, son of Ishwaraya, Chandrasekhar, son of Ishwaraya, Divakar, son of Ishwaraya, Bhanumati, daughter of Ishwaraya, Vasudev, son of Ishwaraya, G. Sada Lakshmi, daughter of Ishwaraya. So during the pendency of this SFP before the Supreme Court, Ishwaraya, who is the legal heir of the protected tenants, Ramalingam, he was contesting the matter. Therefore, when he died, his family members were brought on record and nothing prevented them. This Barbesha, Narmada, Usha, they never contested the matter before the Supreme Court. They are having well knowledge. So this is a decree copy which was finalized in the year 2000. May 9, 2008. In spite of getting the orders in the Supreme Court, these all types of false litigations are being contested only to see that I come to their terms and give some money. In the year 74, when Sir Brahmalingam died, they were very much in the village. They have not taken any steps either to set aside the order. Even the landlord could not succeed in getting the succession of protected tenant declared as null and void. The matter was raised in the Supreme Court, but the Supreme Court nullified the case. So, in spite of getting this order in the Supreme Court, these all types of false litigations, OS 1863, they have.
Now, what is the order of joint character data?
Joint character order in the that is the order wherein I was removed from the land. I was evicted, legally evicted. Thereafter, the matter was carried to the joint collector by tenancy effect. They have violated the landlord, even though they received the lands under Section 45 of the Tenancy Act. he did not cultivate the land personally, because as per section 2G of the tenancy, Telangana tenancy clearly stipulates that whenever a land is resumed for personal cultivation, it must be cultivated directly by the person who resumed the possession, but not with the help of any persons who are given their labor in the form of crop share. So that was the only simple section 2G violation I succeeded in the Supreme Court. He has leased it. After resuming the land from, I was a protected tenant, I was evicted. After my eviction, he has sublet the land by way of lease to the other persons. So the MRO has conducted the inquiry, Tehsildar conducted the inquiry and passed an order that the landlord has violated the provisions of section 2G of the Tenancy Act. Therefore, the protected tenant is entitled for resumption of the land. So that litigation ended MRO. The MRO has ordered in favor of the landlord that he has employed by servants. But the servants has specifically in the deposition spoken that I was given 1/4 of the crop share, not in wages. Therefore, I succeeded in the tenancy appeal. The matter was carried to Supreme High Court by CRP. CRP they have won. I have gone to the Supreme Court. That Supreme Court pendency, they died. In spite of this order, still today, I am not able to get the proofs of this order. For the last more than 60 years, this matter has been litigation. This is the second or third round of generation. I am unable to get the proofs, Merit. As far as the other documents.
Now civil litigation has been turned to criminal.
No, for the exam, so because I got the order in my favor, they wanted that this order should not be implemented by hook or crook. Therefore, this type of litigation they are going, and even that Barbisha during his lifetime, he was inviting so many customers that this is the land basing on the false promises. He collected the amount from so many persons. So that material is there. We place it before this honorable court with regard to how after 3 years, while these persons were attending the court, they have moved an application before the court. Then 324 is not sufficient. 307 is to be made. And the PP also, being a public servant, he has filed a petition against the police. In fact, he has to defend the police. He has filed a petition for which I have also made a criminal of prosecution. That application was rightly rejected by the magistrate. That once 324 is there, 307, no ingredient was there. That petition and order copy with regard to the other civil proceedings between the parties in clubbed with this Supreme Court SLP booklet and the orders of the Joint Collector and Court, I will be permitted to place before France for the final adjudication. Some case will be in the meanwhile, since it is an old matter, the trial court is now insisting because now there is no question. Even otherwise, the counter case, it appears that they are taking some steps. I do not know what is going on. So anyhow, if I not such the case or counter case has to be tried simultaneously with the same court. The date is there, same persons are there, same police station is there. Only the difference is time 21 and time 22. Even the High Court order while quashing has given some simple row of hope to the police. So in view of my submissions, the option may kindly consider providing some additional material because what I have now represented. Some time will be there. Meanwhile, some interim statement, nothing going to happen. In the meanwhile, the other case which they are going to face, they will also take out some shape. Even I have also, after the orders of the Honorable High Court, I have also taken some steps before the concerned police to say that permission is obtained from the magistrate and the case has gone like that. Everything will come out if the office and court are trying to the same court. The truth will come out as regard to the civil proceedings and other all aspects. What I know. What can be educated there?
Then I know. Whatever he says about the civil proceedings, there is no way concerned with this matter. Present before this honorable court could be more regarding the case. I think he had to two ladies and all of them directly involved, as per the witnesses, all of them are directly involved in the crime. As per the demand report, complaint, and depositions of eyewitnesses, that is LWS. As such, and accused number 1 to 3 has been committed. They have filed suspicion, they have not committed before this court, before the lower court.
Okay,
the lower
here later. Meanwhile, I'll say those proceedings.
Staying over here.
Date.
5th of December.
7th of December.
Stay of the right.
I think, have you received IA1? You can stay into. Yes, no.
Stay of the entire.
Have you received IA1 of 23? Yeah.
Before the lower court, very
Case encounter with the seconds.
It cannot be grounded.
Respondent number 10.
It is the clear-cut case of
The
all federal proceedings and referendums. If correct proceedings are paid in the question. One would be the deep first. On the civil, if he has he can proceed with the case and prove himself. It cannot be done, but I have my only opposing partner. There are the answers to the the arguments are that they are clearly mentioned upon this.
That means that is justification.
Even the temple
For detailed examination to add the criminal sanction for a strong idea of the permissions made by them. Was the permission based on the court inclines travel for the proceeding, including the appearance of the petitioner pending
appearance of these petitioners may be dispensed with. Or only the appearance of these petitioners can be dispensed with. All proceedings of this CC cannot be stopped. That's why the petitioners before this honorable court will be dispensed with from appearing before this court till the disposal of this.
Okay, you write the order and you assign.
Copy by tomorrow.
We'll get it in the
Marshal.
On December 7th.
Item number 25, Sri Ajay Kumar Madisetti, public prosecutor. Item number 25, Sri Ajay Kumar Madisetti.
Applicants also should know how to maintain the decorum of court. Can't test our patience. To representation. List on 28. No.
Item number 26, Sri C. Haripreet, Sri S. Ram Sharma, public prosecutor.
What is the offense?
Enhancement of the maintenance and also.
Next.
The right and patient control to have an emergency. The full family not awarded.
That's one. One is notice is served on the respondent.
Yes, I'm sure.
Yes, and verifying the work.
Notice papers to down. Notice papers to down.
We'll see because the vacality is not pending. I used it on 28. Not representation. Respondent. Next.
27 is adjourned. Item number 28, Sri Almas Begum Mohammed, public prosecutor.
For the petitioner in this matter, Your Lordship, the notices was returned unserved. And last occasion, this court has ordered this to serve the notices through court, Your Lordship, and I'm not aware of the status, Your Lordship.
You're not audible, madam.
Your Lordship? I am for the petitioner in this matter, Your Lordship. The notices served, personal notices served have been returned, and the same has been filed, proof of services has been filed, Your Lordship.
Yes. It is returned unserved.
Returned unserved, Your Lordship. The proofs have been filed, Your Lordship. And the last adjournment, this court has ordered the registry to send the notices, Your Lordship.
Shall I issue fresh notice to the correct address?
Yes, Your Lordship.
Issue fresh notice to the correct address, and postal notice is permitted. File the proof of the same. List on December 7th.
Item number 29, Sri Mullangi Ram Reddy, Sri MS Chandesh, Public Prosecutor.
Who is representing respondent? You are representing. Yes, what is? Suspicion 25% deposited. When should I? It's drawn now, 15th December. Second matter, what about second?
Same. Both are.
Okay, 15th December. అంతేనా పడతాడు ఇప్పుడే అప్లికేషన్ the amount
Yes,
but was not December 15th.
Item number 31, CP Lakshma Reddy, Public Prosecutor, Sri Hari Krishna Kumar.
The wife, she filed a say number 301
additional material.
Section 120 of CRPC. Second respondent.
But where is the respondent come from?
This is Boards are bifurcated. After transfer method, petitioner known financial to the petitioner. Petitioner was not aware about the MC. He was set apart and his part. The order to be set aside and
Have you filed satisfaction the court delay?
no. My lord, this issue to the petitioner. It was not done. Or doing that, my lord, unfortunately.
Yeah, they're right. The respondent was served with a notice sent through the registered post, but he did not turn up. So the court, having held this at service as sufficient settlement.
Not received any
questioning an opportunity, my lord, hearing the same.
So in view of bifurcation, earlier the matter was before the family court Rangareddy, later it was transferred to Malkajgiri. Judicial district number 201 of 2021 in the file of the Honorable Family Court. Correction, petition, notice to petitioner and respond number 2, I think. Respond number 2.
2 Malad. 3 and 4 are represented by respondent.
Okay, that's to respond number 2. So both the petitioner and respondent notice may be issued and giving opportunity to both sides after hearing the both the petitioner and the respondent. Whether the court expedition giving opportunity of hearing.
Item number 32, Sri P. Venkateshwar Rao, Public Prosecutor, Sri Lakshmaya Kanchan.
The respondent was yesterday I filed the work.
Yes.
And that 4 is to file.
It request for concept for responding for filing counter list on 13th December.
Item number 33, Sri P. Prabhakar Reddy, Public Prosecutor.
On 21st. 31st account for petition.
Page number 3. Item number 34, Sri M. Vivekananda Reddy, Public Prosecutor.
Notice is served, madam. Guided proof of service along with acknowledgement.
Noted received as one.
Give the US account.
10648 of 2023.
Yes, yes, it is here, but it's not in the one.
Yes,
The register is directed to put up USR number 106486 of 2023 and list on
Same madam.
Monday's holiday, 14 11.
So
Item number 35, Sri Venkata Ramanaya K, Public Prosecutor.
The court name is wrongly mentioned. So yes, second district judge Jalganagar is the right on classes. Instead of this, we have mentioned additional metropolitan session that is Hyderabad typing number.
R2 notice not taken.
Okay, in the grounds you have wrongly mentioned. So instead of additional metropolitan session court, Cyberabad, what it should be?
Second additional district.
Second addition, district judge LB Nagar Rangareddy. Additional metropolitan session, Cyberabad. The court members, second addition, district judge LB Nagar Rangareddy district. Even though is better. Amended for.
Our mistake.
Yes, yes, might be you have mentioned that I have. Punish the amended for. Next.
Date.
A case order only for correction.
Yes.
Order copy other issue.
Item number 36, Sri Karnam Ramesh, Sri S. Ravi Kumar.
May I please your lordships?
Amendment.
Only for Farbin. Clarification. Yes.
May I please your lordships? Lord, I am appearing for the petitioner in this revision petition. I have an interim order, my lord, till 12th. If the other side is ready, my lord, I'll commence arguments in the main case itself.
Extension person.
Lord, this revision petition is filed. Lord, questioning the proceedings of the Honorable Senior Civil Judge in IA number 226 of 23, OS number 41 of 23, 2013. Lord, the IA was filed under Order 7, Rule 14, seeking leave of the Honorable Court to file certain documents. Documents are annexed to the petition filed in the court below. Last may kindly go to page 13.
Page 13.
Yes, please. Page 13 indicates the list of documents that sought to be filed along with the application. But these are all.
But I think there is no pagination here.
Oh, I'm very sorry, my lord. I'm extremely sorry, my lord. Pagination is there.
13 of the CRP or IA?
IA, this is 13 of CRP.
Okay.
13 of CRP.
Yes, yes.
I have filed a copy of the petition filed before the lower court, which is not annexed here as page 13.
Yes.
Page 13 indicates the list of documents, but these are all on the last in tabular form they are shown. Yes. Original Patadar passbook and online integrated land record and online statement of proof of Raitu Bandhu scheme amount paid by the government. But the purpose for which these petitions are filed have been explained in the affidavit filed before the lower court. That is at page number 12. Page number 12. I would only read one para because only one para is stated. I state that though the respondent created the fake disputed documents, but no single gunta of the land is deducted from the suit land until this day, the suit land is in possession and enjoyment. But this is the purpose for which I filed this document. In order to show the possession and enjoyment, because suit is filed for declaration of certain documents which were registered in favor of third parties by the defendants. Questioning those documents, seeking a declaration that those documents are not binding on me, and also for perpetual injunction. Last may kindly go to the prayer portion of the plaint. Page number 25. Page number 25 indicates that the suit is filed for two purposes. One is page 25, last para. It is therefore prayed. This is the prayer made in the court below. For declaration that the suit documents number 365 of 13 dated 7/2/13, 366, 367 and other three documents which were executed by the defendants were sought to be declared as not binding on me, one portion. The second prayer is to decree for perpetual injunction for restraining the defendants from interfering into the possession of the plaintiff basic. So these are the two reliefs prayed in court below. Now last may see the reasoning portion of the order passed by the Honorable. The Honorable Court below considers only one aspect, that is declaration sought to be made in respect of the documents. Kindly, last may kindly go to operative portion from para 8 of the court, page 9, para 8 of the order. Page 9, para 8.
Yes.
May I read this one?
Yes, please.
It used to be mentioned that the suit is for a declaration that the suit document number 365, 366, 367 are not binding on the plaintiff. The said documents bear the date as 7/2/2013. What is required to be proved is that the plaintiff was having right by the date of said documents. Documents ought to be filed as subsequent documents and they are of the year 2019 and subsequent thereto. It is to be mentioned that petitioner did not mention any events for not filing the document now sought to be filed at the earliest point of time. It is also to be mentioned that in the suit, the issue is whether the suit scheduled property, this is important. Well, this is how the court considers. Is ancestral property of defendants 2, 4 and 5 and whether the sale deed number 365, 366 are null and void. The suit is not for a declaration of title of the petitioner or the suit schedule property. It is not relevant to consider the petitioner is having title subsequent to the suit or the suit schedule property. What is required to consider is as to whether the petitioner was having right over the property by the date of execution of the above said sale deeds. Furthermore, since the petition is filed at the stage of arguments, that too after arguing the suit partly, and as the documents are of recent times, the petition is to be dismissed. My respectful submission is, court has not considered the second prayer, that is in respect of perpetual injunction sought for. So in order to prove, secure the injunction, I'll have to establish the possession also. So therefore, as on the date of filing the suit, these documents were not in possession because the revenue department did not issue the passbook and other documents, integrated land records. These documents were subsequently given in my favor by the department, and I sought a prayer to introduce these documents for the purpose of showing my possession and enjoyment over the property. But the court below has not considered this aspect. It has only considered the application in view of the prayer made in respect of declarations are to be made against the documents. Therefore, my respectful submission is that so far as filing of the documents are concerned, the rule doesn't prescribe any time limit. Kindly, my lord, I would invite your lordship's attention to the concerned rule. Order 7, Rule 14. It says, my lord, even it can be filed at the time of hearing the case. But I would directly go to 14.3. Order 7, Rule 14.3. Because one speaks about filing of the 14.1 speaks about the documents filing along with the plaint, and 2 speaks about the documents which are not in possession power. Then third, the Rule 3 is relevant for this purpose, this application. A document, may I read this? Sorry, I'm sorry.
Yes, Order 7,
Order
Rule
7.
3.
Rule 3, my lords.
Order 7, Rule 3.
14.3, my lords.
14.3, yes.
A document which are to be produced in court by the plaintiff when the plaint is presented are to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. But it doesn't contain any time limit. This says when it is not produced at the time of filing the plaint, it can be subsequently filed with the leave of the court. Therefore, my lord, I had to file this application seeking leave of the court, but realizing the fact that I'll have to establish my possession and enjoyment in order to secure an injunction, perpetual injunction. But the court did not consider the possession aspect, my lord. It has only considered, it says, as the suit is filed for a declaration of a particular document as not binding on me, the right should be established as on the date of filing the suit. Therefore, these documents are not necessary. Court has, with predetermined mind, has dismissed my application is my respectful submission, as it has not considered the possession aspect for the purpose of granting decree for perpetual injunction. This order doesn't sustain in view of the law is my respectful submission. This is the short submissions. Therefore, and one more aspect is, even these documents are issued by the government authorities, and no prejudice will be caused to them if they are allowed to be marked and evidence is led. And one more aspect is, the Lakshmi kindly go to page number 38. I had to file 2 applications because, as in view of the closure of the trial, I had to file 2 applications. One application for reopening the evidence, the other application for seeking leave to file these documents. The other application was IA 206 of 23 was allowed, but in fact it was allowed, permitting to reopen the evidence. Sorry, I'm sorry.
The evidence was allowed.
Allowed. And this application is dismissed strangely, saying that these documents are not necessary for establishing the right. But this is not for establishing the right. These documents are necessary for establishing the possession and enjoyment in order to secure the second limb of the prayer in the plaintiff's my respectful submission, which has not been considered by the court below. Kindly page 38, this status source, IA 206. I could only file the status, daily status of the courts, HIGHCOURTs. I'm sorry. IA 206 of 23 is allowed. Suit is reopened. IA 226 of 23 and 28 dismissed. 226 is for leave.
Against that, this revision.
Yes, Miras. Yes. Therefore, Lord Ashme see, it will not, even if these documents are marked, these are only documents, Lord, issued by the government. I have not created these documents. And nothing, Lord, no prejudice will be caused to them. And further, it will give an opportunity to establish my rights before the Lord court below is my respectful submission. Ashme kindly, Lord, allow my application is my respectful prayer.
Yes, what is?
Obliged.
The suit is filed in 2013. After 10 years of completion of all this, they filed this document. That's why the land had not considered the document. It is a delayed access only. And these documents already filed, Patadar passbook already filed. Now they are filing Telangana Patadar passbook and Raitu Bandhu statement of bank statement and integrated online integrated land records. After Telangana government amendment of the revenue laws in 2020 itself they have given entire state. Now they are
what prejudice is caused
conservation.
If it is allowed?
Yes.
I think it would help in adjudication of the issue.
The documents is not relevant for this.
No, relevant or not relevant. During hearing and disposing of the matter, it can be.
It's a suit for declaration, cancellation of the registered documents. Their first title shows me that.
No, just now he has shown me the prayer.
Their prayer, they shown prayer.
I think the prayer is on page 25. Page 25 is the prayer.
If these documents is declared by the honorable court, null by it, automatically they will.
No, see the prayer.
Yes, I observed.
25. For declaration that suit document so and so. To declare as those are not binding on the plaintiff to claim the rights also upon the ransom.
And also for perpetual injunction.
Constantly it is not there, but in the prayer column they mentioned.
And to decree for perpetual injunction for restraining the defendants from interfering to the possession of plaintiff basing on the suit documents in the land of the plaintiff, survey number 15 to so and so.
Dependent contention is in the suit itself. This land not belongs to this document not belongs to this survey numbers. That is created by the petitioner. They have taken the WS.
This document is not pertaining to
Not
this
pertaining
said
to
survey
the
number.
Our documents, which we have got registered.
What are your documents?
Registration documents.
Which this 365.
66 and 367. It is not a agricultural land. Already it is converted non-agriculture. They are purchased plot wise. So if these documents.
So according to them, these documents are not pertaining to the subject line.
Yes, that is plea taken in the place also in the airport.
And,
that is their case. That is their case, Lord, not our case. It is their case that this document doesn't relate to the suit property. But that's not correct because.
According to you, this document 365 of 2013 and all pertains to the subject property.
Yes, miss. But they say that this document doesn't relate to the property which has been owned by me. See, I'm sorry, I could not specify the property which I am owning in the document. This is in respect of two extents, small extents of land. The petitioner is owner of 34 guntas in survey number 15 and 23 guntas in survey number 19 of the Maktal village, Lord. And these documents were executed without knowledge of the petitioner executed in favor of Mulad. This first document was executed by D2, defendant number 2 in favor of D1. And second document was executed by defendant number 4 in favor of defendant number 3. And the third document was executed by defendant number 5 in favor of defendant number 3. So I have made all the parties, the executants as well as Mulad, the participants. Therefore, Mulad, ultimately, it is for the court below to examine whether this documents relates to the subject property or not. Thus, that issue may not arise for consideration of this honorable court in the revision petition. Now, what is to be seen in the revision is whether these documents which I have filed seeking leave of the court to adduce the evidence, whether does it serve any purpose is the question. Lord, I have specifically mentioned in my application that in order to establish my possession, I have filed these documents because your lordship kindly appreciate, except the Milord, the documents issued by the revenue authorities, there will not be any other document showing my possession over the land, possession and enjoyment. There will not be any other document. Therefore, Milord, I have filed the recent documents which were issued in 2019 and 20 only for the purpose of establishing possession and enjoyment over the land. Not for Milord, first limb of the prayer in the plaint. The second limb of the prayer in the plaint is to be established with substantial documents is my respect. Therefore, however, the court below Milord did not consider that aspect. It considers it is a question where whether these documents which are sought to be declared as not binding on me has no relevancy with these documents. That is how the court below has come to conclusion, dismiss my application. But whereas the court did not consider the second aspect. Now, Milord, in order to establish my possession and enjoyment, and I may have to produce the documents which are recent in nature, Milord, which indicates my possession. And the government has also issued, Milord, certain benefits in my favor as a right to bandhu and other things. Therefore, Milord, in order to have a prima facie view of the case, these are necessary documents, is my respectful submission.
Petitioner here in that not explain the delay, why is not filed in the year 2020 when they are producing evidence. After completion of plaintiff evidence, dependent evidence, a case is posted for arguments.
No, what he says is the order 7, rule 14, rule 3 says that at any time with the leave of the court, he can file.
It should be in limitation, limitation act applies for all. Then there must be honorable.
But still, however, what prejudice is caused if those documents are taken, it will only help in the adjudication of the issue.
Cross-sub law and lenient act is mirror, that is 10 years is completed. That is only my comment. There is no prejudice to me.
Okay. I pass the order.
Nice. Grateful to you.
Good. Interlocutory matters. Item number 37, Sri Azar Shravan Kumar, Sri M. Satish Vinci.
Representation. 28.
Item number 38, Sri Kondadi Ajay Kumar. Yes, ma'am. Sri T. Vishwarupachari.
For adjudication of the issue taken. Road 14, sub-road 3, living with leave of the court, it can be. Yes,
38, I think.
38. Yeah. Who is representing the respondent?
Filed by insurance company, the appeal stay, subject.
You're for the appellate. You're for respond number?
Respond claimants.
Respond.
Present application filed seeking permission to withdraw. Since he was a minor, he could not withdraw at that time. They obtained stay subject to deposit 50%. Major amounts have been withdrawn. But by the time he was minor, his amounts were kept in fixed deposits. Now he's seeking permission to withdraw.
Yes, what is? This is IA1 of 2022. Some correction has been made.
One more submission. This appeal is filed by insurance company, whereas claimants also filed appeal. Kindly post together for final recapture. I'm giving number.
Present appeal is by the insurance company.
Insurance company. Connected appeal, I am giving number. Claimants appeal. Kindly post next week for final.
Along with the present appeal and return. It's filed by the claimant. And IA1 of 2023 is filed. The other matter and this matter will be listed together. Which date shall it?
So finally, next week I'm ready.
Okay. On 20th, 20, under the caption.
Item numbers 39 and 40 are connected matters, my lord. Simply Achyut Ramashastri, public prosecutor. Yes, ma'am.
Representing? Yes.
He has been appointed.
Has been appointed
Make a
as
screen there, appoint time.
counsel record was not attending the matter.
In which matter you are saying?
39 and 40.
40.
39 and
40. Can పేరు ప్రింట్ అవ్వట్లేదండి
అవునా
అమ్మాయికి పేరు రాలేదు.
I'm appearing for respondent.
But her name is not coming.
Not printed, mother. But on last occasion, this honorable court has appointed her as the.
Unda. Which court? Which court of the no representation of the presidentship is indicated by the not several legends in the portion from appointed as an increase of for this. By order dated 13/10/2023. Son of Council. was appointed as an to represent the revision petition. The said name is not reflecting in the house list. So it is directed to print the name of Annapurna Sriram for the revision petition. అట్లాగే మనం చేయలేదు appointed the audit data also by this investigation. So, interpretation, as the name is not reflected in the cause list, this is directed to printer name. List on 5th December.
Item number 41, Sri Annapurna Sriram, CS Nadu.
Yes, you ready in this one? Be ready. Why are you taking time in all the matter? Okay. List on
మాధవి మాధవి వక్కలట్లేదు కౌన్సిల్ రెస్పాండ్
respond. ఎవరి పేరు చెప్పండి.
మీ వక్కలట్లేదు.
7th December. Yes, 7th December. File your vakala. Yes, yes, but she says it's not in the window. Okay.
Item number 42, Sri T.S. Anirudh Reddy, Public Prosecutor, Sri Sudarshan Reddy.
Not necessary, it's only an aspect because they have already compromised with regard to the other accused. This is the order.
But we didn't have any instructions.
ఎక్స్టెన్షన్ కోసం
What my management is saying that
ఎక్స్పైర్ అయిపోతే వేశారు
Passed on the order.
ఎక్స్టెన్షన్ పిటిషన్.
Petitioner is A2 with regard to A3, A4 already passed.
And petitioner is A2.
A2. The allegation against him is that it's a case where he was charged for offense under why not T85. The allegation against him is that the wife of the petitioner was working with his respondent. The both institute of yoga institute is run by the complainant.
The wife of the petitioner
Was working under him
okay.
as a yoga trainer. But one of the accused who stays in Bangalore, there was some difficulty between them and he resigned. Immediately the petitioner also resigned. So all the staff resigned. Bangalore, Hyderabad, they resigned. So immediately the first he asked all the three ladies to come to Jagannath temple at Banjara Hills. They came. The allegation so far as the petitioner, who is a software engineer working in England, he came to India. He took his wife because to the Jagannath temple to talk with the complainant. The allegation against his that the petitioner has given some gestures to his wife, and the wife of the petitioner has shown it to the complainant, saying that we demand 40 lakhs. That is the case against him.
Who has made gestures to the wife of the petitioner?
The petitioner has, as a husband, has given some gestures to his wife standing long distance.
Okay.
It is said that the now allegation is that the wife of the petitioner, who worked under him, has shown something in the cell phone saying that 40 lakhs. They are demanding 40 lakhs for withdrawing the. In fact, a 376, 354 ABCD case were registered against him in Bangalore. Charge sheet is also filed. Therefore, he compromised with them, those people. But first, two submissions. First submission is some of the accused they have already passed with regard to compromise, and the case cannot be segregated and passed. The second thing is even taking the allegations as it is in the FIR, as in the charge sheet, no offence is made under 385.
that has to be decided on merits, date of hearing.
Well, it's going on. He stays in England.
I never asked him that. They are asking lost all occasions.
Why should
extension
I
of interim grant.
But in between, I have brought your lordship very recent order of this honorable court.
Yes, yes, I think, but they have compromised.
Yes, they have
The
compromised.
matter has been compromised between 8-3 and 8-4.
Yes.
But this is not a quash petition, right? This is a discharge petition. Against the discharge petition is filed. In login state of hearing, it can be finalized.
Let it be on.
So when A3 and A4 is compromised, why don't you compromise with
Just
the?
now I came to know that I have no instructions. I'm not counsel for this.
Have you filed quash petition regarding the first petition?
With regard against the discharge application, we have to necessarily file a revision. That is the reason we have before your lordship. With regard to A2, Malad, it is before the other court.
That's what I'm asking. Whether quash petition has been filed regarding this
With
petition.
this, with the petitioner, only revision. With regard to his wife, it is criminal petition.
But against him also you could have filed on FIR.
So against the discharge, Malad, we find a revision. We have to find a revision.
This is a different aspect against discharge. But quashing is a different aspect.
Washing is there. Against I filed an discharge application in the trial court.
Followed about that.
Yes.
So discharge petition is filed.
That is the reason.
But I also have filed on FIR quash petition.
She did not file discharge, but she has straight away filed quash.
That's what I'm saying. You could have also filed quash petition.
No, I can't file. When I invited an order from the lower court on a discharge application, I should file only criminal last.
Instead of that FIR.
No, not FIR. It's a charge sheet. Charge sheet is filed.
Charge sheet.
Charge sheet is filed, and after filing charge sheet only we can file a discharge.
When was that quash petition of 3 and 4 filed?
Very recent.
After filing of charge sheet or at the FIR?
Yes.
It shows me after filing. Recent.
Because Malad, he was now worried about the Bangalore case where she filed a case. The other A3 and P2 or accused, they filed a case against him.
Against the respondent.
Against the respondent that sexually harassing.
So in view of that, he had to compromise.
Compromise with them. Malad, not on merit, even on merits, Malad, my respectful submission.
Okay, what are the grounds for discharge?
First of all, Malad, take your lordship to the allegations in the complaint.
But I think, are you in a position to argue? You are taking some time.
10 days time I'm requesting. That's a waste of time. I'm a land and valuable time also. That's why initially I asked.
Monday or Tuesday, Malad, want to argue the case. That's all. Either way, your lordship either allow or this.
Yes, yes, we'll hear it finally. 10 days. When, which date? 28th, Monday, Tuesday. Okay, then. We'll hear it, sir, on that day. Request for counsel for respondent. Counsel for respondent list on 28th November. And IF 5 of 2023 is filed to extend interim stay granted in IN number 4 of 2023.
Dismiss it.
What dispense petition? So this is extension of interim stay. Stay granted earlier is extended till then early. 28th November.
Item number 43, public prosecutors, KV Sudhakar.
Yes. What is that? You have filed condone delay petition. How many days delay? What do you say? What do you say?
Coming for 664 days.
64. Yes, what do you say?
These are registered by the agriculture office. This is the seed.
According to him, it is 600 above days.
180 days has to be deducted for the limitation.
He's disputing the days. You want to file your file counter disputing the days? What do you say on that?
This is the agriculture officer, you know.
What agriculture? I'm asking about the regarding condone delay days. He says some difference is there.
Even when the transfer, also they have to take the.
Okay, I'll take up on some other day. You verify. 20th November. At request of Assistant Public Prosecutor. Please take proper instruction. Is disputing the days you have written from 237, 600 above days is telling. Take instructions and represent.
Page number 4, final hearing matter. Item number 44, Sri Ram Mohan Palanki, Public Prosecutor.
No representation for the petitioner list on 21st November. Next.
Item number 45, Sri T. Mahindra, Sri K. Venkatesh Gupta.
Yes, sir. They're representing in this one. You have your calculation? You have your calculation ready with you?
Yeah, bill is filed by the insurance company.
That's what it's filed by. Agreed by what order?
We are disputing the medical bills which are filed, relying on which we what is passed. They were not proved is our case.
Only medical bills.
Medical bills. And we are also saying that there is contributed negligence on the part of the injured claimant. These are the two grounds on which.
So when there is contributory negligence on the injured,
Yes.
what is the legal position?
And if contributory negligence on the part of the petitioner, then the negligence contribution will be deducted to that extent.
Okay, some part of the amount.
Yes.
What is on that?
Another thing is, me, my lord, another petition also there. In that case, they are not filed any appeal by them. It itself proves that there is no.
I think, no, you have to satisfy on his contention is that contributory negligence is there on your part.
Court will not calculate that on that part.
Okay, prepare synopsis and give. And you should be thorough in that, just so don't simply take passover because you should be prepared as a reason. When do you want? And legal position also on these aspects.
Judgment also that I'll file.
You need to be satisfied the court because the appeal is filed by them. On those two grounds we have heard, I think.
Yes.
Only on those two grounds. Which date you want?
Next week.
14th? 14th at request of counsel for responding.
Item number 46, Sri Akkam Ishwar, Kota Subbarao.
Claimants are claiming not case of injuries for enhancement. Claim
Case of injuries.
Yes.
Yes.
Claim made of 1,50,000. Awarded without 61,000.
61,000.
61,000 awarded.
What is the agreement?
The announcement not case. See the number 2 page 6 of the order may not paragraph.
Yes, sir. Page 6. Page 6, para 10.
Para 11.
Para 11. Okay.
Coming to the quantum of compensation of the Exhibit A3, attested copy of medical certificate of the petitioner issued by medical officer, government area hospital, Kamarati. In Exhibit A3, it is mentioned that the petitioner sustained swelling, tenderness, and pain over the right shin, and the petitioner is referred to Gandhi Hospital, Secunderabad for better treatment, and the petitioner took treatment in Balaji Hospital, Hyderabad. PW2 is the doctor who issued Exhibit A3 injury certificate. PW2 doctor stated about Exhibit A6 letter issued by PW2 doctor. In Exhibit A6, it is mentioned that the petitioner sustained fracture of femur. PW3 is the doctor who treated the petitioner. PW3 orthopedic surgeon of Balaji Hospital, Hyderabad, stated in his evidence that on 24/7/2011, the petitioner admitted in Balaji Hospital with fracture of 1/3 short. After receiving radiologist report, PW3 doctor performed surgery to the petitioner on 26/7/2011, and the nail was inserted to femur. The petitioner was discharged on 30/7/2011
PwC doctor further stated in his evidence that the injuries mentioned in Exhibit A4 and A5 are the corresponding to the injuries mentioned in Exhibit A3. PwC doctor stated in his evidence that the petitioner requires further operation for removal of the nail from right femur. PwC doctor report about Exhibit C1 case data of the petitioner. From the evidence of PwC2 and 3 doctors, it is held that the petitioner sustained fracture of right femur and the petitioner undergone surgery and the petitioner admitted in Balaji Hyderabad for a period of 6 days. In view of the above circumstances, sum of 25,000 is awarded to the petitioner towards pain and suffering. Considering the evidence of PwC doctor and considering the fact that the petitioner sustained fracture injury to his right femur and other surgery. In the private hospital, a sum of 10,000 is awarded to the petitioner towards hospital and medical expenses. Since the petitioner sustained fracture injury, the petitioner might have been taken bed rest at least for a period of 2 months. As such, a sum of 8,000 is awarded to the petitioner towards loss of income during the treatment period. A sum of 10,000 is awarded to the petitioner towards transportation, extra nourishment, and attendant charges. PwC doctor stated in his evidence that the petitioner requires further surgery of removal of nail from the right femur. In view of a sum of 8,000 is awarded to the petitioner towards the future medical expenses. Thus, in all, 61,000 is awarded. That without a previous injury without of surgery, only 25,000 is awarded without of pain and suffering. Expenses without as well, and extra nourishment without is only 10,000 is awarded without of. And during the loss of income without treatment, 8,000 is awarded. All without very low amount is awarded without. Then without some higher amount without case of injury without surgery has been taken. 50,000 has to be awarded without, only 25,000 has been awarded.
50,000.
All these without.
And what about
extra nourishment and
extra nourishment?
Yes, not attendant charges without has to be 25,000 without.
Okay. And
Doctors, for
what
example,
about the loss of income? Monthly, how much?
Is only taken without 8,000 without.
How much is he earning monthly?
$10,000 without.
8,000 has been given. Where is the income certificate?
It is no income. This work has been $1 million by the tribunal. We supported documents without the FIR and charge sheet the jury certificate.
Then on what basis shall I increase it?
6 minutes surgery has been taken.
No. This income during the treatment. Loss of income, I'm saying.
Yes. Maybe taken 8,000 2 months not considered. This extra nourishment and the parents suffering will have to be enhanced.
Okay. Extra nourishment. Yes.
There is no evidence for income aspect.
Yes, sir. That's why it's going on only for.
Simply for pain and suffering.
Yes.
On the surgery, 25,000 is granted. Maybe increase for further 5,000 or so.
Okay. Pain and suffering. And what about the extra nourishment? 10,000 is there. There also I can increase. How much I can increase?
Total about 20,000 it is.
So 10,000 is 20 shall I go for nourishment? 20, and about payments of, shall I give?
5,000.
No, 25 is there.
I shall make 30.
50 can be given?
Yes.
50 means 20.
50 maybe 40 lakhs, 40.
40,000 is giving me not
40?
40,000.
40 can be.
40. So 40 and here 20.
Yes.
So 25,000 will win.
Yes. Yes.
Okay. Payment total. And attendance external arrangement, principals.
One date of appeal.
Date of appeal.
Yes.
Okay, from when they filed. Okay, what is the date of appeal? From date of, I can just simply say from date of appeal.
Yes.
Okay. Interest on enhanced amount.
Enhanced.
Interest on enhanced amount. This will be carried from date of appeal. Okay. Next one.
47 is adjourned. Item number 48, Sri Chandraya Somavarapu, Sri B.L. Prasuna.
You're representing insurance company. No representation for the petitioner. Request of respondent counsel list on, shall I say 23rd? 23rd November. Be ready. I can anything.